A few years ago, I had the privilege of defending one of the country's biggest companies, Walmart, in one of the biggest class action cases to go to trial in the state of California. We were very cognizant that in representing Walmart as the employer, that the jury was looking to us to see how the representatives were treating the employees. And they were going to come to a conclusion about how Walmart treated its employees by how we treated the employees. This was a landmark case because what exactly an employer had to do to provide meal periods to their employees was unclear. This was one of the first cases that started a huge trend in the state of California that focused on wage hour claims. There were literally dozens and dozens of new cases filed every day against employers. Most class actions, almost all of them in fact, routinely settle well before trial. Usually the risks are just too big for companies to take. But Walmart was one of the companies that was big enough and brave enough. So the plaintiff's whole theory of the case was that all they had to do is look at these digital records of meal periods and count whether they were short or not short or missed or not missed. So they simply went through the records and counted all the allegedly missed meal periods and said, we're owed an extra hour of pay for every single one of those. It was important for us to make the jury understand that the time records told only part of the story. And the way we did that was with the very first witness. He took the stand, and on cross-examination, we asked him, Mr. Davis, is it your contention that you never took a meal period? And he said, no, of course not. I got most of my meal periods at Walmart. I just would miss one or two a week. So at that point, we were able to pull up his actual time records. When you looked at those, it looked as if he never got a meal period during his entire tenure at Walmart. And we asked him point blank, Mr. Davis, those records are not correct, are they? What we established was that those records told only part of the story. Because this was a cutting-edge case that was really defining what it meant to provide meal periods in the state of California, employers from around the state and in fact around the country really focused quite closely on our case, the rulings in the case, and ultimately the trial. The judge ruled that employers had to ensure that their employees took meal periods. We had a very different view of that, but at that point we had to take the ruling that the judge gave us. And so we tried the case on that premise, and the jury did in fact award the named plaintiffs and the class they represented a pretty significant amount of damages. But again, that wasn't the end of the story. We always knew that the company could appeal this verdict and argue that the trial judge's initial ruling of what the law meant was incorrect. And in fact, that's what happened.